Welcome to our roundtable discussion. Obviously, this is not a round table, and obviously this will probably not be a discussion because discussion always seems to imply calm and rational and respectful consideration and a discussion for others' ideas. And even though we're discussing legislation and the work of changing the laws, behind that, as all of us know, are a lot of feelings, and they do have a way of coming up. But first, I would like to introduce our roundtable panelists. And I'm doing this in alphabetical order as it was done in the syllabus, so you can follow along if you'd like. This is John Bernstein. John is the Assistant General Counsel of State Farm Mutual Automobile Insurance Company. He's responsible for governmental relations and activities in the states of Illinois, Michigan, Indiana, and Ohio. John is a professional lobbyist. Janet Fenton, who's at this end of the table to my left, is currently the president of Concerned United Birth Parents. She's a reunited birth mother, and she has had extensive experience in working on legislation in the state of Iowa in a number of areas. Mary Ivanek, to my immediate left, is a social worker who is a consultant to government agencies and to committees in both Australia and New Zealand, and has worked on adoption reform, or as Ken Watson said this morning in his keynote speech, adoption reform issues. And she was instrumental in achieving landmark legislation to open records in Australia and in New Zealand. Robin Quinter, to my right at the far end, is the American Adoption Congress Communications Department Director. You've probably seen her running around with lots of media types, and that is what Robin will talk about. She is an adoptee and an adoptive parent and co-founder and director of ABSN, Adoptee Birth Parent Support Network, and a professional journalist in the Washington, D.C. area. So welcome to all of you. The panelists will probably talk a little bit more about their experience and their background as they respond to the questions that I have and that you will have. Well, we're here today to discuss the hard work of changing laws. As you probably all know, while no law is sacred or written in concrete, for those of us who are struggling to open closed adoption records statutes, those statutes come as close to any as being both sacred and written in concrete. But you will also hear from our panelists that a lot of hard work and a little bit of luck, and in some cases a lot of luck, can change those records. While the experts, both here and there, can't tell you what to do in your individual states, what they can do is provide information based on their years of experience that may help you decide what kind of decisions you need to be making in your states about opening records. So the plan for the workshop is this, that the panelists will respond to some questions that I'll have first, and we'll go until about 2:55, and about 5 of 3 we'll break, take a stretch break or a bathroom break or whatever, and then we'll start right again, and from 3 to 4 the panel will entertain questions from the audience as well as from myself. And I'm very hopeful that this will be a real hands-on participatory session, even though we're lined up in this way and you're lined up in that way. We need to imagine more of a round table feeling. So I'd like to start, I think, with Mary Ivanek from New Zealand. And I'd like you, Mary, to talk a little bit about your legislative experience as you look back on opening records. And I'd like each of the panelists to talk about what they mean by open records.
Well, it is now about 14 years ago that I became involved at starting to look at opening of records. And partly that was due because in England they changed the law in 1975 which gave us in New Zealand an impetus to start and do something about changes of the law in New Zealand. Looking back, it seems that we achieved a lot in a short time, but starting working at it and during that time it seemed tremendous hard slog with extremely up and downs, a lot of hard work with very little reward, very depressing at times and very joyful when you made little gains. And I guess what we learned looking back overall is that change, as we heard this morning in the speech, take a planned approach with setting of goals, limitations, compromises, hard work, knowing your facts, do your back homework, and start with clearing where you are yourself. It's very hard to convince other people if you're not clear about the issue yourself. So when we look back at ours, it took us 10 years to get the legislation. It passed in 1985. It took 2 years for planning and preparation and strategizing, and 8 years of actually having a bill in Parliament all the time in front of the House. It seemed a long time, but when you look back, to change a system from a total closed system to probably at this time the most open system in the world, 10 years is not a hell of a long time period, really. Looking back, we have learned from our mistakes. There are things in the Act which are not working very well, and capitalizing on those, I was able to work with the Standing Committee on Social Issues at New South Wales, Australia, where we could incorporate our mistakes, things that weren't working, and hopefully give them the basis for legislation which will improve on ours if that gets passed in October. So all I can say is it took a lot of hard work, but it's very worthwhile.
Mary, do you think that your experience is applicable to those here in the United States?
Yes, I think it is. There is a framework of how you go about things, and I think Ken Watson's this morning was a very good framework. There are differences, and I think American culture is different, and every policy is made according to the social forces in society at any one point in time, and what is acceptable to the general public and the politicians. And that will differ from country to country, and what each country has to do is, what are the issues here, who is the opposition, where does it come from, and that may be slightly different in different countries. But I think the approach and the process are actually the same, and I think we can learn from each other about that.
And could you tell us a little bit about how you dealt with the privacy question? I assume that was one of the opposing issues you dealt with.
I guess we first finished up with people being opposed on the basis of breaking up families, the adopted family and the adopted person, and changing the law is going to break up the family. Then we made it very clear we're dealing with adults and not children. Once that message got across, it was then while we have to protect birth mothers. When birth mothers are coming forward with their submissions, it then finished up with the privacy and the legal aspects of that, and we must protect regulations and rules and promises made in the past. We got around that by really looking at how did the legislation come in force in the first place. And when you look at history, it was very clear that most adoptions were made when the law was still open, so that privacy hadn't actually existed in fact, and it was based on myth. And when you talk about protecting privacy, it wasn't birth mothers who said they wanted their privacy protected. And once that came across, we had this issue of should it be retrospective or not. And as most people signed their consent when it was open, the issue of privacy had really been not proven to exist anyway. Mm-hmm. So that was based on false premises.
Mm-hmm. How did you actually get started? Because I think a lot of us who want to work toward open records, how did you start? Did you do it by yourself? Did you have a committee?
No. I don't think anybody can change the law by themselves. I think we had a few prophets in about 5 different places in the country, and we had about 5 centres spread from the north to the south. It's a very long sort of country. And 5 main centres had a small group. And each group was loosely connected and focused on different areas. In the Auckland area, which is in the far north, and a third of the population lives there, Jigsaw was set up on similar basis as Jigsaw in England. And they established a national register. So the rest of us did not bother setting up a register. We'd refer everybody to the one register because it doesn't work as well anyway, and if you start having these little registers, then it just becomes more confusing. So they concentrated on that. They also start helping people search under a closed system. We did the same in Wellington. We set up support groups in Wellington because it's the capital city and head offices of government departments and parliamentarians were there. In Wellington we got also the Register General of Birth, Death and Marriages, National Archives, all those kind of things were there. And the Wellington support group concentrated on gathering information over a 100-year period. In particular, Keith Griffins was very involved with that, and we helped him along to get all the data, all the information, all the parliamentary debates, every court case, every media report ever published on adoption over a 100-year period. And we were able to do that in Wellington because we had access to all the central things. Christchurch was set up as a result of Keith being a Methodist minister, setting up with a social worker in Christchurch and their social services as an adoption support group, and they became the core voluntary agency with support. And Dunedin was a colleague of mine who was a social worker, educator, and he started there. So we had these 5 centres, very loose-knit, and very much starting both working at support and help people search under a closed system, at the same time also actively involved in legislative change. We are aware that some people feel you have to separate those 2 things out, but I don't think you can work in isolation. You need to have the masses available to back you in your legislative change. So if you lobby and write a member of parliament, or you ring or appear on a talkback session, you need the group members to ring in and make sure that there is some feedback in. So it meant you had to keep people together, each with different functions. We asked people to identify sort of things he or she wanted to do. And everyone is at a different level. Some people are so much in pain they're really not able to have the energy on legislative change. Others had sort of go past their bit and had a lot of energy. Some people had a dead end and were just so angry, and it was really good to do something concrete and search through records, etc. It just needed a planned approach to things. And
what did you
let's have a
find
look.
most effective in terms of reaching your
Right.
parliament? Yeah.
Having looked back now, I just finished a piece of research for a Master's in Public Policy, which I just completed. And part of that study is I went back to members of Parliament and asked them, what made you support this bill? What influenced you to change your mind? And the most profound thing is that the most important thing what changed people's minds or parliamentarian was the personal stories of Triad members. People who made personal appointments with their members of parliament and face to face talked about this situation, the effects on their lives. If they could bring their husbands or their parents, the grandparents who lost the child as well, etc. That had the most profound effect on helping them change their stance on open records. So as Triad members, you are the most powerful tool you have yourself. It's no professional or academic or anyone else can do for you. So therefore you have the power to change. and it was the personal stories made face to face. The second important aspect was the personal letters, not standard letters, which they found supported the individual stories and built on it. Thirdly, it was their own personal experiences in their own family or friends. If they'd had an adopted child in the family or had friends who were adopted and whatever, that also had changed their views and perceptions of it. Fourthly, it was the literature that dealt with the dispelling of the myth. Now, a lot of members of Parliament were under the impression that the reason for close records was based on very good reasons, research or whatever. And by actually pointing out the process of what had happened, how records had become closed, and on what basis, was absolutely astonishing to many MPs who found it quite unbelievable. And by actually being able to show them word for word the debates, the discussions, the interdepartmental committee minutes, and all those kind of things, really make them reconsider that, in particular in relation to confidentiality and the promises made by lawyers and social workers and so on. And fifthly, it was the research of the aftermath of reunions, which reinforced that things were going all right, sort of thing. So these were the things that absolutely were most instrumental from the legislators' point of view. And this is sort of interviewing them 3 years after the event. So,
Thank you. We'll come back to everybody, and you'll have plenty of time to ask more questions. Jen, would you tell us a little bit about your legislative experience and your background, and then maybe again address what you mean by open records, what your sense of that is, and how in Iowa, what kinds of things you need to do and not do?
Well, I'll try. I have been interested in the legislative process for years, and in a lot of other aspects. It was in about 1983 that we began our work on a comprehensive bill in the state of Iowa. That was my first experience in lobbying on an issue that touches me this personally, and that is a very emotional issue. We began by getting together some of the groups in Iowa that were interested, some of the adoption reform groups. Some were actually in existence then. Others were just a loosely formed coalition of people that was formed for that purpose. And just began setting down the priorities that we felt we needed to deal with on this issue. At that point, we needed to enlist the help of the people in the legislature, get legislative rules, or legislative service bureau people involved, helping us do the drafting. And we decided early on that we all had some bottom lines that we felt were important to us. For those of us in Concerns United Birth Parents, for example, we felt it was very important that all parties be treated equally. For a lot of reasons. We just felt this was a much sounder base to begin with. We would have... Sure.
How long will you be?
About 2 minutes.
2 minutes?
If anybody doesn't want to be on, I'm going to be shooting the room. Who doesn't want to be on?
And where is it going? What station?
Channel 7.
Channel
For the
for
news,
tonight?
yeah.
For the news?
And also a half-hour special on adoption, which will air in June.
I'm comfortable with that. Is there anyone not
Anybody else?
Okay, fine. Again, we all felt we had some bottom lines, and we worked out an agreement with the people involved in this early coalition, so that we felt we had an understanding of where the various groups were coming from, where their bottom lines would be. After having a bill introduced that first year and having it go absolutely nowhere, we did have a public hearing, and in Iowa that really is a good signal that that's about all that's going to happen with a bill. If we get a public hearing, we felt we at least had a chance to energize some of our own troops, but we knew that was probably as much as was going to happen. We then, I think, really began the work of getting the bill going, because we formed a coalition with agencies, with professionals, with just about anyone interested in changing the laws, and began a long, hard summer of drafting a compromise bill that we felt had a chance of getting through the legislature.
And could you describe that bill a little bit? Because I know that I've seen bills, for instance, that are one-page bills, and I've seen bills that are 2 inches thick. And so, Janet, if you could share with us what the Iowa bill and the Senate.
Well, it's been a while. We're going back to 1983 here, but really it was an all-encompassing bill. We felt that in Iowa we would have a better chance of getting something passed if we really addressed the whole picture. If we talked about what we felt was important information to be shared with pregnant women, for example, to give them the information we felt was necessary to make an informed choice. We also talked about the period for revocation. We talked about the whole thing, not just when records should be available to all parties of adoption, but the whole total picture. What monies could be expended, for example, by people providing help to pregnant women and that sort of thing. So I mean, it really was pretty much all-encompassing. We were certain that we wouldn't get everything we were asking for, but we thought it was important to address all of these issues and also to have some areas we knew we could compromise on eventually.
So those are the reasons. So there are reasons for doing that sort of
Right, and then again, going back to that original coalition, everyone wanted something. Foster parents felt that there were a lot of things that they needed to address in their situation. Adoptees, birth parents, adoptive parents, some agencies. We worked long and hard with agencies who felt there were problem areas.
Tell us about, if you could, a little bit about opposition that you ran into in the state.
Well, I think that we were able to neutralize a lot of the opposition from agencies simply by working very hard and working often with these people over a 4 to 5 month period and working out compromises prior to the next session of the legislature. This, I think, had a lot of nice side benefits, too, because we discovered agencies really had no idea what they were doing. Practices of one agency might be totally unknown in another agency. So not only were those of us who are directly affected by adoption unaware of what agencies do and how they're doing it, they didn't know either. We also were able to forge some good, strong working relationships with some of those people that have endured over the years. I know I feel personally differently about some of the people working in some of the agencies than I did prior to that. I got to know them pretty well, and I think they feel a lot differently about birth parents and adoptees.
Thank you. We'll come back to you, too. And John, from a professional lobbyist point of view, get that for you. From a professional lobbyist point of view, I assume there are some differences between a professional lobbyist and a grassroots lobbyist. All of us are grassroots lobbyists. So would you talk a little bit about that, and again about how those roles are different? What could we use? What approaches might you suggest that would be helpful to our situation?
Well, first of all, there really is no major difference between a grassroots campaign and a professional lobbying campaign, because a professional approach will use, if available, a grassroots campaign, particularly if your lobbying effort involves a public event or has a support in terms of a great deal of people who are interested in the subject. In our case, we do some lobbying through professional lobbyists who I supervise in the various states, and but supplemented by our agents, employees, occasionally even State Farm policyholders. So if you can, the more you come at the legislature from more angles with the same story, the more effective you could be. Moreover, you're much more effective, as I said in a meeting this morning, if you one-on-one can talk to your legislator. He is going to be, or she is going to be, much more responsive to you than would be with a stranger coming in who can maybe buy a ticket to your fundraiser, but really is not a voter. That voter is really important. So the best lobbying effort is both the professional who can talk issues, technical issues, who can testify or arrange testimony of experts, but coupled with an effective grassroots campaign, that's the best. Now, I sat here and I was wondering, we've been talking about open records, and I would like to ask a question back, and that is precisely what do we mean by open records? Do we mean, in fact, total open records from day one of the adoption process? Or do we mean something less? Do we mean, yes, we will respect the rights of the privacy of one or more of the triad for however long that person believes that privacy is necessary? Or do we mean something else? Do we mean only that the adoptee at a certain age has a right to open access to the records? Is there a veto on the part of someone else in the family, etc.? So we've got, I think, to define what we mean, what we're trying to get at before you engage in an effective campaign. And the second area I might want to discuss is you really have to do this state by state. New Zealand might be a great example, but it's still a relatively small, compact, contiguous country. We have 50 states, some of which are not contiguous, a great variation in statutes, a great variation in the common law underlying those statutes, and the response of the common law to the statutes. And so I think we're probably going to have to do this somewhat piecemeal, although there have been attempts, I guess, to do this through congressional efforts in Washington. But I suspect that the answer is going to be state by state. So you're going to have different campaigns with different bases, and an Iowa approach or a Hawaii approach may work in Iowa and Hawaii, may not work at all in Illinois or Florida, and so on.
Well, let's let Mary Ivanek respond first, and then Janet, if you could respond to it. Okay.
Firstly, I think that in terms of how relevant is New Zealand experience to New Zealand, I think New Zealand is as big as the state as Colorado, with the same number of population. So I think you have to keep it in that perspective. England, of course, have a much greater population, and they managed to change it to 1975. And I think many states in the US will be smaller than England is. So I don't think that it means bigger means harder. I don't think that's necessarily the case. In terms of your campaigns, of course, it's different with an issue like adoption, abortion, homosexuality, which have to do with people's value system, their beliefs, their attitudes, their morals, etc., which is different than the kind of campaign you would have when you're dealing about an economic issue or a party political issue. In the case of adoption, members of Parliament in New Zealand were given a free vote. It's a conscious issue. Therefore, parliamentarians are a bit at loss how to do things. Because when you don't have your party political machinery behind you telling you how to vote, and that each individual is going to be accountable to their own electorate how they voted on things, they all run for cover and really not quite know what to do. And they will do all sorts of ways of trying to get out of it or avoid it or put the responsibility on somebody else. So your campaign will have to be different in every state, because it will depend so much on each individual personal member of Parliament, or your congressman or senators, whatever you call them here. I'd also like to point out there has been changes in legislation in Australia, which is also much bigger than New Zealand, where the similar approaches are being used. Obviously, it seemed to me you have to do it state to state because of the different laws in each state and the different parliamentarians you're going to have to cope with their attitudes and their beliefs, and you need to work on each individual. I wonder what the other questions were.
What do you mean by open?
Oh, open records. Well, to us, open records meant all identifying information available to you as an adopted person, or so that meant in New Zealand you have access to your original birth certificate and any other identifying information held about you on departmental government files or adoption agency files. And from that information you should be able to identify your family of origin and make contact with them. We make services available to help people search because often there is marriage searches to be done, etc., electoral roll searches. In New Zealand that service is free of charge to any applicants, so that money does not prevent people from finding out their true origins. So with us, open records meant having access. However, there are compromises to be made, and in our case we did have a veto in place, which meant that either a birth mother or an adopted person who did not want to be contacted could put an endorsement on their birth registration, preventing identifying information being given out. This is a compromise we would have liked to have done without, and we probably would have been able to do without a veto for adopted people, but in that case we would not have succeeded getting any legislation giving birth parents rights. And our bottom line was that both adopted people and birth parent must get rights, that both need access to information, and we were not willing to compromise that, so we had the veto for both systems. It seemed to us a minor thing to compromise on, although it denies the ultimate right to access to information. We knew that very few birth parents or adopted people would want to use it, and that's proven to be so, and that our experience of searching under closed system had become so sophisticated that anybody having a veto, we most likely would be able to find their background anyway, and that also has proven to be right on the whole. So to us that was a risk we were willing to take rather than give away the idea of birth parents not having right at all. So these are the things, so we have open records, but there are these limitations of a veto. It has proven that the veto is very ineffective because people are still able to search, and what has actually happened is nothing makes people more determined than search and get a veto. And usually people have a veto. When you don't have a veto, you search and you contact the person you want to have contact with. This is the adopted person or your birth parent. With a veto, some adopted people or birth parent assume the adopted person or the birth mother is not interested, and therefore once they find out who they are, they tend to go to other members of the family, putting the birth mother more at risk than she ever was before. So we are saying the veto has not served us very well, and in fact has put the birth mother, who is usually the one who's placed a veto, more at risk than she would have if there was no veto. So we hope that that's something we can change, having got that kind of feedback now.
Thanks, Mary. Because of time, I'm going to go right. Thanks, Janet. And then, does that help you?
Well, I think so. I think what it means is, A, you have to be willing to compromise to get something done, and B, you really have to define, maybe I ought to put it the other way around, you really have to define what you want to begin with. And what you want may vary from state to state, because you may have to realize that in some states which have been absolutely sealed, that do not have any type of registration in effect, that the best you're going to get is some type of a registration system, and or you may say, well, let's go for broke, but at least you have to define what your goal is, and go for it. And be ready to compromise. And I think New Zealand's an example. They had to compromise.
Good timing. What's the question?
Robin, actually, appropriately enough, Robin, it's about the media.
Jeez.
We have just
I've seen enough of them today.
some of. But I guess my question to you would be that I was talking to a newspaper reporter recently, actually from Des Moines, and she said to me that although she is very interested, obviously, in a lot of topics and very open to learning about issues, that she has found it difficult to understand or to empathize with the vacuum that particularly adopted people describe and birth parents. And so I guess my question to you, and maybe focusing on legislation, is how can we approach the media in such a way, or such ways, that they will better understand this issue?
Well, dealing with the media is always a very tricky and complicated process. And you really have to first identify the media and who they are. And sometimes you can be surprised in knowing who the media are in your area, that they're not exactly, I mean, it's very obvious, the TV, the radio station, the newspaper, but there are a variety of other media as well. And sometimes those are the kinds of professional press, trade press organizations, and things of this nature, which can be very important in any kind of lobbying and legislative effort. Now, one thing that I find in my experiences as with AAC Communications Director have been that we actually kind of have to handle our success stories, our stories about wanting to know, needing to know information about ourselves or our children. We have to handle them very carefully, because chances are the press is not attuned to or sensitive to the adoption issues, so we have to do a bit of education with them first off. Secondly, we have so many successful search stories, and they often do receive a great deal of press, that we have to be very careful how they're handled, because people look at that and say, oh, well, these people find each other all the time, so there must be some kind of success, so why do we need to open the records? And that's an image that is often conveyed inadvertently. And we have to be very careful when you do highlight a search story in the media that it is used, it's very clearly used as an example of, look, here are people that overcame the odds, and this is how they did it. And this is exactly the kind of system that they have beaten, and this is someone else on the other side of it, perhaps here, is still searching and all. What we did this morning with the reunion story, if you saw the media running around here, we had an adoptee reunited with 4 siblings whom she had not seen in over 40 years. Now, her story was such that she was old enough when she was adopted that she remembered their names, so there was no any even slightly gray area of behavior in obtaining her birth name and finding her siblings. To contrast that is her adoptive sister, who is still very actively searching. And many of the media, fortunately, are portraying her story, featuring her story as a contrast to that. So it'll be interesting to see the news tonight, the Tribune and the Sun-Times tomorrow, and see exactly how they play that. We've been able to use that as an example of the kind of the pain that sealed records causes. And until you are able to personalize that for the media, until you're able to do something more than just say, gee, you know, I had questions I always wanted to know, you have to say that with conviction. I mean, it's the kind of thing that it's a very tricky road to handle, whether before you cross the line of what is appropriate, what's inappropriate behavior, you don't burst into tears at the same time. The tears sometimes add to it. And there's no hard and fast rule about it. It depends upon the media and the person that you're dealing with, and how receptive they're going to be, and you never know up front, and how genuine their interest is, how sensitive they are to this story. And it's a very tricky road to do. It's a very tricky one to handle.
In talking with Mary a little bit last evening, my understanding is that they used the media in the sense of really educating the legislators and in making the legislators accountable for some of their opposition to this.
Well, I think there are a couple of areas of difference that we have here in this country. We have, I think, a lot more media in these states than in New Zealand, and that's just one issue in terms of quantity to deal with. We're fighting 47 battles in 47 states, and that's a lot to deal with for AAC. Secondly, we have organized opposition to us. And whereas opposition is sometimes one-on-one or an individual here and there that pops up that's opposed to this, we have an organized force that's very well financed, or at least it has been. We're hoping they're on some financial hardships soon. We have a very powerful, influential voice that speaks against us. And they have a professional paid staff, they have member agencies throughout the country and parent groups that they can mobilize. Naturally, coming from an adoption agency community, they also have a level of professional participation. Some of their adoptive parents are professional news people, professional higher-ups in the government. It's really nice when you can send out a letter from William Simon, who used to be one of the top government officials, in a cabinet letter soliciting funds for this particular organization. So I think that is one area that we have to combat that was not true in New Zealand. We would not be able to hold members of legislatures so much accountable as to why did you vote against this, and let the media do that kind of thing for us, for a couple of reasons. One, I think it's more likely that they would be held accountable. Why'd you vote for it, not why vote against it? And that's a position we don't like to be in, but I think it's maybe one of the inevitable positions we have to accept at times. Secondly, I think we have more of an issue to deal with in terms of anticipating the arguments that the opposition uses and being able to shoot them down, doing the research and the homework, the research homework, background work that is needed. One of the things that this organization, AAC, and that search groups and groups, adoption reform movement in general, we're all volunteers. You know, it'd be real nice to have a survey of how many people are actually out there searching. It's a question we're asked all the time. And yet there's no accurate estimate, and there's not a real good way of getting an accurate estimate. It's a very difficult situation when you're not under one umbrella, when you're as fragmented as our organization is.
Let me
Yeah.
respond to some
Sure.
of the media questions on how to deal with that. And Janet, I want to come back to you too about the...
Coming back to the media, I think that's true, that you have many more different medias here, but much harder to educate is when we have sort of 47 daily newspapers in New Zealand, but they tend to get a lot of their news from a central bureau which people feed in and it gets reprinted. So in a way that's an advantage, and you don't have to sort of convert different people. But I would just like to point out the opposition. We had very organized opposition by the most powerful people in the country, first being the Prime Minister, the Leader of the House, the Minister of Justice, and the Minister of Social Welfare, who were all opposed to the Act, as well as the Department of Social Welfare Head Office, who made a submission opposing the legislation. So I won't like to give you the idea that we had no opposition. And the reason it took us 8 years through Parliament was purely because the Prime Minister and the Leader of the House are in charge of the order paper. And they were able for 5 consecutive years to prevent the debate coming up into Parliament. And it wasn't until we had a change in government that we were able to then have at least the bill to a vote and then won 2/3. We first we had questions raised in the House in 1976 by a member in Parliament. We then had petition Parliament. We had further questions asked. We were finally only able to get a member of the opposition backbenchers to promote a private member's bill. And that is how our legislation got passed eventually, a private member's bill of the opposition originally. The government threw it out 3 times, The fourth time they agreed to send it to a select committee, because by that stage we had really worked with the media and said to the media, look, there are certain individuals in government who are preventing due course of parliamentary procedures. And they really took that up. So as a result, the government allowed the bill its first reading and have it referred to a select committee. And this was in 81, and it had started in 76. In 81, the select committee had hearings, and 95% of the submissions were in favor of change, which totally floored the people who thought that would be the end of it. When it reported very favorable back to Parliament, it laid upon the table on the order paper for a second discussion. And it was the Prime Minister and the Leader of the House personally who then kept it right up to 1985 back on the order paper. And several times it came near the top, and then an hour before the sitting, the order papers were withdrawn and a new one issued, and it came back. At other times, when it was at the top, all of a sudden the Prime Minister moved that an urgent issue had come up, which meant there was no time for private bill discussions, and it disappeared. So they've actually used every legislation they could use to not have the bill debated in Parliament through the personal power of some very powerful politicians. Members of the government became embarrassed by this vengeance of a few powerful men in cabinet to undermine democratic process. And so we were gaining votes that way. We then had a change of government, and the Labour Party had promised they would give it the full process in Parliament, and we had then, it finally got passed in 85. So, you know, we had very organized opposition from a very few powerful people who, for whatever personal reasons, did not want this to go.
I'd like to come back to open records again. And if you could share with us, how can we handle that when people say, what do we mean, what does our organization mean by open records, or what do people in individual states mean when they say to their legislators and their friends, we're working for open records? Can you help us?
Well, I think we really have to look at this on a state-by-state issue. I couldn't agree more fully with what John said. This has to be dealt with on a state-by-state basis, and at least for us in Iowa, we had to look at what we could reasonably expect. We're a very closed state, and while a lot of us would have liked to have had even more openness than the original bill proposed, we felt that was a compromise we could begin with, and that at that time would have meant records available to birth parents, adoptees, and adoptive parents when the adopted person reached the age of 18. From there, we needed to make some additional compromises that we were not happy with. But again, we all had a bottom line beyond which we felt we would no longer support the bill and could no longer support the bill. For those of us in Cub, that meant keeping equal access to all parties. And as long as that was still a part of it, we felt we would continue to support that legislation. Something that Mary said earlier made me want to respond to about the business of the party vote and that sort of thing. That was something that when we did manage to enlist the help of some professional lobbyists in Iowa, and some of the legislators themselves were very much surprised by the reaction that legislators have to this kind of an issue. It certainly isn't something that can be handled in caucus, at least not in Iowa. And what we felt we could best do to deal with this was to early on enlist the support and help of majority and minority leaders in both houses. And while we were certain that we weren't going to get that support from some of those people in power simply because either they were on record as being opposed to this or we suspected they were going to be, I think it was important for us to be upfront with these people, to ask them clearly what we could expect and what we should do to try and gain their assistance in working through the process. And I think while it tended not to change anyone's position, really, any of the people in power. It made it possible for us to let all of our supporters know where the problems were likely to be. And I think that it at least it let people know that we were being upfront about where we were coming from, and they knew right away what we were asking for.
I think what I'd like to do is take a real short break, 4 or 5 minutes, come right back, and then we'll open it up to questions. And I know there's some experts in the audience, as much as any of us are, who can ask questions that we run into in our own states. I'd also like to tell you that we now have 48 states that have closed records, because this year Alabama sealed their right to the birth certificate for the adult adoptee, and now it can be viewed only upon court order. So that while I think in some sense there's a trend towards some willingness on the part of some legislators in this country to grant us some measure of openness in terms of the registries and intermediaries, which personally I'm very deeply opposed to, but I know there's difference of opinion out there. Nevertheless, I think there's also going to be a backlash against the notion that adult adopted persons and their birth families have a right to all of the information about themselves from their birth onward. I think we're going to have a bit of a backlash, so we do have a lot of work to do. But come on back, and we'll try to talk more about how to do that. Thanks.
This marks the end of Session 8, Part 1. Please turn to Session 8, Tape 2.
Mike, I wish you guys had spoken up, because we would have gotten this sooner. I didn't know that we weren't on a real mic. Before we go to questions from the audience, I would like John to take just a couple of things that have come up during the break. One is to talk a little bit about what makes an effective lobbyist, because John is an attorney who trains lobbyists, and also to talk maybe a little bit about drafting a statute and how to go about finding people to do that.
I'm not sure whether I should take first things first or second things first. So I'll do first thing first. State Farm is a large organization, as most of you know. Perhaps not Mary, but we're the largest insurance company in the United States, and I think about almost twice as big, just short of twice as big as Lloyd's of London. So we're quite a big company, and we have professional lobbyists in about 40 states or 45 states, not every state, but almost every state. What we look for primarily are not the glad-hander types of the old days. We look for knowledgeable, credible people who understand issues, who can speak privately to legislators in the quiet of their offices, who have, as I say, a high degree of credibility. That is, they don't lie. They tell the truth. They tell it like it is. They may have to occasionally buy a ticket to a political function. They're often but not always lawyers. They're often but not always men. As a matter of fact, I would say probably 20% women now. And they, that's the key thing. The credibility. It's very important. It would be very nice, frankly, probably well beyond the means of the American Adoption Congress, if we could afford to have a paid lobbyist lobbying a good bill, making whatever deals are necessary with supervision, voluntary supervision, of course, in all 50 states. That obviously is not going to be not in the financial picture, I guess, right now. So the next best thing, and we have had that, we have a number of people, some of whom I've already met in the short time I've been involved in this, who are knowledgeable volunteers, who can go down to Springfield or Lansing, Columbus, Indianapolis and talk to legislators who know who is in power, know the key committee chairman, the people know how you get something through rules to the right committee, know how to talk to legislators, and that is certainly a step in the right direction, probably the best we can do. Frankly, I'm not convinced that other than the media advantage of and there is some, having marches on Washington and the like. I think what you need is a good basic statute or statutory reform, a fallback position knowing you may have to compromise, and beforehand understanding where that compromise is going to fall and where you will not permit it to fall, or at some point beyond where you're going to go. So that's critical. And finally, you need to have as much coalescence as possible. Not only do you have to build coalitions, which is also extremely critical in any legislative effort, but you've got to have at least the great majority of people who are in the adoption movement, whether they're associated with your organization or not, agreed as to what the legislative strategy ought to be and how to go about accomplishing what you want to accomplish. The statutory drafting person, well, I don't know whether we're diamonds in the rough or what have you. There is very little training in law schools as to how to draft statutes. I've done a lot of it. It's mostly been learned by doing, and looking what other states have done, looking at the pattern of how you draft a law in the particular state you're interested in. But it isn't an insurmountable hurdle, but you can always get a lawyer for relatively small money to do some drafting, initial drafting. In any event, there's a legislative drafting service that's associated with each legislature that will put the bill into a final legislative form.
Thanks, John. Janet, I'd like you to talk a little bit about the complexity of adoption code, so that when we talk about open records, we have to sort of put it in that context, and a little bit maybe about strategies. Someone came up to you during the break and talked a little bit about strategies, or wondered about.
I don't know that I'm really able to address that first question very well. In Iowa, there are only 2 sections of the code that really are much affected, and well, they are large sections, I guess. Well, basically that's why we decided to go for a pretty all-encompassing bill, one that would deal with just about every aspect of adoption. But maybe I don't understand that first question very well. And
Strategies.
well, strategies. Again, we felt it was important to involve all of the people affected by this. That was the reason for forming the Adoption Reform Coalition, for getting the agencies that facilitate adoption in Iowa involved and working out a compromise prior to the submission of a bill, because it was pretty obvious to us that legislators weren't wild about addressing such an emotional issue in the first place. And unless those of us who were most directly affected by this could come to some kind of agreement, they really weren't even going to deal with this issue. It was very unlikely it would be allowed out of committee or beyond something such as a public hearing, perhaps. One of the things that we spent a lot of time doing beyond that, I think, was identifying people willing to do some work for us, because what we're talking about in Iowa is a very small group of people committed to do this. The adoption reform movement in Iowa is small. It was even smaller then. And of the people in that movement willing to speak out, I mean, when you get down to that, you're talking about a dozen, 2 dozen people tops in the whole state. what we began doing early on was asking everyone that came to any meeting at any time to please give us names and addresses and phone numbers of family, friends, anyone they knew that might be willing to talk to a legislator or write a letter to a legislator. And we began compiling a list of people across the state, and then began the long, hard work of precincting all of those names and addresses so that if we needed someone to contact Joe Brown in Montezuma, we could hopefully come up with at least one constituent. And when you get outside the capital area or the Cedar Rapids area, where we also have a Cub group, it's very difficult. We have counties in southwest Iowa that we really, to this day, can't be assured of coming up with the name of one person. This has been going on now for quite a few years because, of course, people move, they grow up, they move away, they die, it's real hard to keep this list updated. And now, with the redistricting and everything, we're going to have to start that long process all over again. But it is very much worthwhile, and it proved itself time and again when we would be down on the Hill talking to people, and then maybe that night could call up somebody from Northwest Iowa and say, please call your senator right now. And that was effective for us because we are so small, because we don't have money. We really needed just those few names, and I think now we probably have maybe around 500 of those names. But again, the list needs to be cleaned up from time to time. The one other thing I wanted to mention was that because of this coalition that was formed early on and the compromises that we finally were able to agree to, we did then have the support and could count on the work of lobbyists from two very credible places. Lutheran Social Services, which is the largest agency in Iowa, has a full-time lobbyist plus other professional people that come to the Hill from time to time. And because they signed on to this agreement, we could count on that lobbyist to work for us, and that kind of expertise is very important, and you can't buy that sort of thing. We also had the support of the umbrella group for all of the agencies in the state of Iowa and their full-time lobbyists. There were 2, sometimes 3 of those folks, plus the support and endorsement of the National Association of Social Workers. And at least in Iowa, their local chapter is very much involved in legislation, and that all came about because of that early coalition that we formed.
The issue of materials to take to
Right.
legislators.
Just one other note on coalitions, some other possible allies to consider are, of course, chapters of NOW, National Organization for Women, ACLU chapters, to some extent, depending on the climate of the social workers or the adoption agency organization in anybody's individual state. But not to overlook people with similar interests, such as ACLU and some of the civil rights-minded organizations that do not particularly, their focus is not particularly germane to adoption, but they have a parallel interest in civil rights, something of that nature. Those are also people who are potential allies in those coalition buildings. I wanted to just briefly touch on some of the things that you need to remember when you are approaching a legislative conflict, so to speak, that there are materials, printed materials that you need to provide. You need to have background statements, you need to have position papers. They need to be well thought out, they need to be planned, they need to be provided in sufficient copies for everybody and their brother.
It'd be short.
And be short, that's it. This KISS, keep it short and simple. I know there are variations of that phrase, but that's one to remember. People, for every particular bill, there are going to be 2 sides, and there are going to be parties on each side. And lawmakers and their staff members get a tremendous amount of paper to read. And they are not going to sit and read the same thing 25 times over again. You need to be concise, and it has to be accurate. I have seen situations in my experience as a reporter, people who are testifying on a bill, trying to get another bill. This may not be related to adoption at all. And they provide incorrect or inaccurate information. And if there is a statistic that is off, I mean way off, totally off the wall, out of the league, and very blatantly so, if there is information that is unsubstantiated by background data, if they request background data on it, any of that, you will be absolutely blown out of the water as far as your credibility goes. And if you shoot your credibility, you have lost your chances completely. So you have to take a great deal of care in compiling a legislative packet and putting together some of the materials. Now, some sample materials might be a position statement. Just say, for instance, let's create a scenario first. You have an open records bill in a state. You have 6 search and support groups supporting it. You have your local statewide coalition or group of agencies supporting it. You are, of course, looking for other allies. But you would have a letter of endorsement in that packet from the agency organization. You might have a similar letter of endorsement from the chairperson or the president of the local chapter of the social workers organization. You might have a position paper outlining bullet items, the key points in this bill. You might have background materials on each of the organizations, if they wish it, maybe a paragraph or two. Most importantly, letters of endorsement, and not all identical, letters of support to be part of the packet that you present to a legislator, that you present to their staff people, and with some embellishments with press releases and things that you present to the press. And you have to take a great deal of care in these. There is a joke around AAC about me being a perfectionist. I happen to be one. It's not an uncommon trait among adoptees. But you have to take great care in this, because if it's slipshod, if it's sloppy, that is not enhancing your image. Because of the situation that we are all in, we need as much help as we can get, and we cannot afford to let something of like a minor detail of a sloppy appearance be something that really screws up our chances at success. So anyway, I just want to not to overlook the value of a media packet, the value of a legislative packet, materials about what you are doing, background references, things of this nature that can all be useful for you. The current legislation in California that's moving through the Assembly, the folks in California put together a dynamite legislative packet. And that's something that has really, really paid off for them quite a bit, because they've gotten a lot of compliments on it, as well as a lot of support, just because of the printed materials and the way it was hand-delivered and packaged and so forth to them. So that's another aspect towards success you all need to think about.
Thanks, Robin. Yes, and we'll go to questions, but I want to say that the American Adoption Congress will have ready during this year, we have a draft of a legislative manual that will help us each walk through the history of sealed records, the description of all of the state laws on sealed records, the sources where you can get copies of the state laws, as well as legislative information. For example, the League of Women Voters, your state capitals, and we'll have a list of all those state capitals and departments of human services. We have a wonderful piece by Carol Anderson from CUB, How to Be a Better Public Speaker, because Robin is talking about the importance of materials. It's also very important how whoever is going to be talking to the legislators in your state present themselves. And there will be other helpful hints in that legislative manual. And we probably also could make the kind of packets that other states are using available. But I also want to emphasize that what works in one state, because they have researched that and those are the pieces of material that work for them, may not work for you. So again, if you have to keep coming back, as Janet said, to doing your homework, or Mary said, doing your homework over and over and over again. Now, let's take some questions for the rest of the time. We have about half an hour. Ray.
This isn't a question, more of a comment. I think we have to be more precise, and John asked the question in terms of what we mean by open record. And I think very basically, I mean at least, that at the age of majority, an adoptee would have access to the original birth certificate, and a birth parent would have access to the amended birth certificate, and at the age of majority of the adoptee. I think that's basically what I mean by open records, and I think countries that have open records, that's what they're referring to. They are not referring to, and I know some of you may refer to, the agency file on adoption. And I'm not saying that's unimportant. That's an important personal document for adoptees and for birth parents to examine, perhaps. But I think in terms of legislation, basically we're asking for that amended or original birth certificate, depending on which side of the fence.
Well, what if one of the parties does not want that information revealed, particularly either the adoptee or the birth parent?
Well, as Mary said, the New Zealand experience has a veto provision. I think a number of laws are retroactive, and we say we're changing the rules now, and I think the same thing can be said about adoption. I think, as Ken Watson has talked a lot about some of the promises that we made years ago on the basis of information and our naive understanding of adoption, we simply have to say we made a mistake back there, we're changing the rules now. And I think legislatures do that all of the time. And I don't think in terms of as I understand this process, that isn't impossible to do. We say it's retroactive from here on. Now, some other legislations, by the way, England said that from today, when the law passes, when people reach the age of majority, they have access. For those that occurred prior to that, they will have to go through a bit of a different process, possibly go see a counselor at the Home Office or wherever Home Office is in England. But just, I guess I'd like a bit of feedback in terms of my definition of what we mean by open records, whether I'm off target or whether people are essentially
Let's
saying
let
the same
Mary
thing.
respond, and then Carol Anderson from Cub is here, and Janet, they can respond from their perspective.
I think on the basis of the New Zealand experience, the Parliament of New South Wales Standing Committee on Social Issues have heard submissions, and they've come up with a report which I think justifies and says we are having total open records with no mediation, no vetoes, no restrictions. Both birth parent and adopted person have right of access as of right of age of majority. And that's how it should be.
But is that that's not for the agency record necessarily, but for
No,
the birth
no.
certificate?
Birth certificate.
Carol, why don't you introduce yourself?
My name is Carol Anderson, and I'm with Concerned United Birth Parents. And
Why don't you come up so people can hear you? You have a soft voice. Can everybody hear me? Okay. Anyway, I can't claim that I'm an expert on why we should do it one way as opposed to another way. What I mean by open records, I don't think the piece of paper is the important part. What we're all looking for is, I don't care if I ever see my son's amended birth certificate. I wanted to find my son. And I don't think that most people who are adoptees who are searching really care whether they see the original birth certificate. What they want to find is their own identity and who their parents are, and be able to find the people involved. And most of the time, the original birth certificate or the amended certificate in the case of a birth parent will be all they need to be able to go on and find the people that they're looking for. But there are circumstances where that's not going to be enough, and I think that it's important that we have provisions in the laws that allow us to look at other documents as well if those documents aren't enough. Because what we have to be honest about here is that I didn't search for a piece of paper. I searched for my son, and I'm quite sure that other people also who were really searching for people and answers were not searching for pieces of paper. I guess as far as the argument goes about not having a veto in there, my response to that is simply that what we have right now is a system that says, I don't care if 98% of the people have to live in sheer hell all the time because we have to protect those too. And I think that's a strange way to look at things. And I think what we have to look at on this is nobody wants anybody to suffer, but if there's going to be an error somewhere, I'd a lot rather see it on the side of openness instead of seeing it on the side of lies.
Let's get some
Yeah,
audience.
I'm Denise and I'm an adoptee, and I think open records doesn't just mean birth certificate, but I know there's a file on me. I was in a foster home for 6.5 months, and there's that 6.5 months of my life that I don't know anything about, and I know my birth mother knows nothing about, and I have a right to that information, especially because of the fact that somebody cared for me. And being educated in psychology, I realized that the first 6 months of a child's life is very critical. And being a mother also, I realized that bonding process that comes along. So somebody took care of me and other adoptees for the first few months or year of their lives. So there's that bond that forms there, plus that information about a child's behavior. And I want to look at that information too, not just my birth certificate, but these are people that had a significant impact on my life, not only in addition to my birth family. So to me, open records means everything about myself, so that when I talk to a social worker on the phone and I hear her going through my file and screening my information as far as what she can tell me, it really makes me angry because she knows more about what went on in my life than I do. And that's my life we're talking about. So I really think ideally open records should be everything that's kept about a person from the time that they're given up in adoption to the time that they're placed, because there's that missing link in one person's life.
We actually have that in New Zealand. You have access to all identifying information about yourself or non-identifying. It's people been able to get for years. But there's a danger in that a lot of the information, a lot of the times there's no file. Stop, clean out, just a card with very basic details, so there are no files. Secondly, that half the information is found to be untrue. So it's actually more damaging to get access to your files than not. Over half.
To take a look.
Right. You know, so, but what actually happens is in terms of foster care, people have access in New Zealand under the Official Information Act. So, you know, that's covered in our particular legislation anyway. But in terms of, you know, most of our prior to 55 Act, there's no information except a little card if you're lucky. And in terms of when you change the law, where do you put your energies? There's only so much money left. You know, there's so much resources. And we actually made a decision in New Zealand when the Act was passed. It was more important to get the birth certificate out, give people information how they can get current, up-to-date information and search for their relatives, than go and look through archive files for hours and hours and hours, know that more than half the time it's untrue anyway. So it's a matter of when you implement a policy, what are you going to put your energies in when the same information can be achieved once you have your birth certificate, you have access to birth, death and marriage certificates and entries, electoral rolls in your certs, and you get all the information you have. So from an implementer on policy, you know, like you're concerned here about the waiting list it takes and all these, you know, we made a decision we will not cert back files until we've got the bulk of the things out. And if you're then really stuck and you can't trace, we will then do a search. So it's a matter of, you know, it's sometimes dangerous to put all your efforts in what happened to me in 6 months when you actually can trace and you can hear it word for word from the person.
So this is what we're talking about as far as the issue of compromise then. As far as, ideally, I think and most adoptees would like to have all that information. But what you're saying is, and I understand what you're saying, is, you need to focus in on what's really most important. And then because I was wondering about compromise and how do we compromise, so this is a good example, I think, where you have to compromise.
Let me give it to Robin, and then the woman in the back there will take the next. One thing to remember is that agency policies in this country are enacted by each agency. And they're arbitrary. There are agencies that, as a policy, will disclose more information than others. And the reason that the agencies have the policies that they have is that they are, in the most part, they parallel the existing law. And they are a separate issue. I mean, I'm talking about privately funded agencies here, not publicly funded agencies. If an open records bill became a law in a particular state, the publicly funded agencies would have to, I would imagine, and I'm not an attorney, so I'm not a great one for this, but my gut feeling would be that would open all of those records at that publicly funded agency. If it were a privately funded agency, I cannot guarantee it depending upon the philosophy of its board of directors, but I would imagine that they would find themselves in a position of being forced just by public outcry within their own community to enact something similar to reflect the law. So I think that, you know, perhaps there's going to be more of an effect from what would be done most efficiently that might achieve what you actually want.
Carol, do you want to respond to that?
Very briefly, I'd just like to say that it partly depends, too, on what records there are to open. And we can't lose sight of the fact that while New Zealand had all agency adoptions, we have independent adoptions here. And in many of those, there are no records to open. And the only records that exist are the court files, so that there is the amended certificate and there's the court record, but there is no agency file. Some lawyers and doctors don't have files going back that far.
Let me just say about my daughter, too, in response to your question, that when my daughter found us and we found her, over the past 6 years, she has returned and gotten the name of the foster parents who took care of her. She has met with them. She has a picture from them of her when she was, at least in the first few months, and we have obtained a legal copy of her original birth certificate. So a lot of us are talking about the process of things here and the order of things, but eventually my hope would be that all adoptees find out everything that they possibly can, you know, about themselves. Now, yes, you've been very patient.
Oh, yes. That's quite all right.
Yeah.
I think I'm going to have a little time Sunday to address everybody anyway, since you're all interested in legislation. We've gotten the bill all the way. House Bill 256 will open adoption records for every adoptee that turns 21. With passing of this, we've got it through the House.
Which state?
The committee voted for it unanimously. Ohio, House Bill 256. We've got it through the House. The committee voted for it unanimously. We had truckloads of adoptees, birth parents, and adoptive parents down there testifying. We do suggest that you do have a copy of anything you pass out in writing, enough copies for everybody on the committee.
I know who you
They
are.
listened to us. They said that is why they voted for it unanimously. We didn't have any opposition at all in that first committee. There were only in the House, there were only 2 votes against it. Everybody else voted for it. Now it's in the Senate committee. Yesterday it was introduced to the committee. Next Wednesday, we think, we're not sure about the exact date, but next Wednesday, the proponents for this bill will speak. I brought some postcards addressed to all people on the committee that I'm going to pass out Sunday. Please, if they don't give me a chance to speak to the whole group, please, at least the ones that are here, get some postcards from me and fill them out and send them in. We just want people, they don't even have to be from Ohio, just to explain where you're at in the adoption triangle and why you would like to see this passed. It's House Bill 256. And we're just hoping and praying that it'll pass. Now, what we're doing here, we have a precedent for this to pass, because lots got screwed up years ago in Ohio, so that some records on a state level were open and some weren't.
Right.
So we worked for 5 years to pass House Bill 84, which passed in 1985. That opened all records. Being passed this long, anybody knows from Ohio. If the adoption is finalized before January 1st of 1964, their records are already open. Now, this will be from here on in, as soon as the adoptee turns 21. Now, birth mothers. I'm not an adoptee, I'm a birth mother. And I haven't forgotten about you. But what I fully intend to do, when we get this through, I don't say if, I say when. When we get this through, I'm going to go back and I'm going to say, okay, first, House Bill 84 set a precedent for House Bill 256. Equal rights for House Bill 84. So House Bill 256 gives all the adoptees equal rights. Now, I'm a birth mother, we're birth mothers, we demand equal rights. And that's Ohio, and thank you.
I'd just like to comment on that. That did not work in Victoria, Australia. They had exactly the rationale, and they had hoped to change it. But they just found that having gone through a long process of getting adoption legislation, no way did the legislators wanted to be bothered to go through that whole process again. So the birth mothers missed out.
Okay, passed it for the adoptees.
Yes, yes.
Okay, in the state of Ohio, I have to understand, you understand now that I'm not saying this. Okay, you haven't heard this from my lips. But in Ohio, it doesn't really matter that much because we can help those birth mothers.
Yes,
It's the adoptees we can't help, so we can still help birth mothers.
Yeah,
So we,
I mean, guess what I'm saying is, when you go for legislation, you get as far as you can get because you don't get a second chance for a very long time.
well,
Yes.
I'll live until
Let's take the woman in the straight. Thanks, Mary.
I was at a meeting with some legislators in Michigan, and they said, if we could give you anything you wanted, what do you people want? And we said, we want open records. They said, define it. We said, we want our original birth certificates. They said, we can't do it. If we passed a law that said you could have it, our vital records can't do it. Because if you as an adoptee send in your adoptive name and say, I want my original birth certificate, in Michigan, they do not know who you were at birth.
They don't
Because
have
there's no
cross-reference?
matching between the amended BC and the original BC in Michigan prior to a certain date. And they can't tell us who we are in Michigan through vital records because they don't know.
Well, that's certainly one of those things I would imagine that
Well, it
it's a
helps
clerk
us
in
in
your...
search, and I didn't say
Sure.
this either, because we can mail out for our original
Sure,
BC
yeah.
if we know our birth name, but if we know our birth name, we probably don't need to.
Right.
You know what I mean?
Yeah, good point. But that's probably one of the things that you know about Michigan that means that your strategy for what
So we
you're
have
going to
to
work
look
for
at-
may be somewhat different
We
than
have
the
to
people
look
in Ohio.
at where the records are in Michigan that we could ask to have open that would help the most people in the adopted community. And in Michigan, it's not the birth certificate.
Somebody else? Yes?
I have a question, Mary. How many people have tried to use the registry or tried to get their records since it has been open?
Since it has been open, we've had 13,600 and something.
Is that a very big percentage?
Yes, it is. Our total adopted population from the year 1881 to current is 10,000 adoption. Now the majority of those, 75% have been done after the Second World War. A third of those are step-parent adoptions. So and also some of them don't qualify yet because they haven't reached the age of 20. So in terms of percentage-wise, we've sort of gone to 30-odd% of people who are adopted or birth parents have applied. When we adjusted by the age from 25 to 35, the adoptees in that age group, with the number of adoptions done, over 50% of adopted people have applied for the original birth certificates. So the myth about very few people need to know this information, then we've actually made it available and freely available to people who want to.
I have a question for Mary. How did you address the legislatures when you got the open birth certificates for those birth parents that denied or said they didn't want this information? You said that it's opened anyway. Did I understand you right?
Well, no, what happens is we use the same searching techniques as when the records were closed. I mean,
Birth certificates are open though, right? Did you say?
no, if there's a veto on it, you can't have a copy of your birth certificate.
Oh, I'm sorry. I thought I understood you to say the birth certificates were open.
Your birth certificates are open provided no veto is placed on it. And so far the number of vetoes is just under 2% of birth parents have placed vetoes.
Okay, so you still afford them that protection if they
Yes, they
want
do,
that,
but it's
right?
actually no protection because we can still search.
Right.
I mean, all it does is it prevents the Register General from giving out the birth certificate. And we've actually put on our pamphlet to people, placing a veto does not mean you can never be found.
Of course.
You know, so that
Michigan
people know.
has a real quandary, the state does in that respect, because there are people who can get two valid birth certificates.
No,
You
well-
know your birth name. You can have two social security numbers, two driver's
Yeah,
licenses.
well, you
two
couldn't do
numbers.
that
You can, you really can in Michigan, if you know your birth name and can get that birth certificate. You've also got your amended birth certificate, so you can be two people.
You can't do that in New Zealand, it's not possible.
Yeah, you can in Michigan, before 1968.
Yeah.
And that's what really upsets the legislatures there.
That's a good reason to change the law, isn't it?
It is. Except there's no cross-reference.
For a real novice at all this, can you give a brief idea of how to go about getting the history of how the law in your state came about? Or where would I even start, work backwards? Or?
You could go to usually your state capitol or your state house has a library in it. And you can ask a reference librarian there for help in finding the adoption statutes that have to do with sealing the birth certificates. You might even want to look at all of the adoption statutes in your state to make sure that when you're dealing with the issue of open records, that it isn't going to change something else that you will then lose. And maybe John can say more about that.
It depends on the state in terms of history. For example, in Illinois, we call Smith-Byrd annotated statutes with sometimes an essay on the statute and very often a time index in terms of when the statute was changed, how it was changed, etc. As a matter of fact, I think in Chapter 83, Section 800 in Illinois is the appropriate statute, and I believe there is a fairly good essay put out by a fairly prominent lawyer following it. So it does give you some background, at least, on the statute and where they came from. However, in other states, there's very little by way of legislative history to go on, and the references are, the old statutes are often thrown out, and all you have is current. Canada, on the other hand, everything that ever was enacted is all there, so it's almost impossible to find out what the current law is. I guess that's the Anglo system. But it really depends. But I think a good step is right. To go to the state capitol, go to the reference room of the library in the Capitol building itself, where the senators and representatives go, and the librarian, I'm sure, will help you.
Thank you. Yes. I have a question for Robin about media. The same House Bill 256 in Ohio, I run a group in Cleveland, and we've had a lot of publicity about the group, and I've heard conflicting advice of whether we should include information about this bill since it's already passed the House, it's now in a Senate committee. Some people say you shouldn't publicize it because that'll create more opposition. Other people say you should publicize it because you'll get more people in support.
That's one of the trickiest balances that we walk in all of this. We have had requests from people in various states to please don't even put this in the decree, which is a fairly limited circulation publication, because we're afraid it'll tip off somebody and the opposition will come in. I think you have to be able to make a very, very careful and objective, if at all possible, analysis of your strength and before you decide to go real public with this. And I don't know the situation with the people involved, and it would be far better ones. I don't think that you need to be public for the sake of being public about this bill. Thousands of bills are introduced in each legislature every year, and thousands of them die, and a few hundred usually are enacted. And even that quantity is such that it's not like every bill gets publicity. So I don't think you need to feel like you have an obligation. If you need additional strength, I personally think it'd be wiser to look for it within your own community, your own group of adoptees, etc., before going public seeking strength. If you feel that you have a strong enough active group working for this bill, you've got supportive key legislators, you feel like you've covered your bases, then I think that's the appropriate time to be more public about it.
I think it is a matter, first of all, you do have, and I compliment my native state of Ohio because it's a good legislature, very good legislature, as opposed to Illinois or Michigan, for example. And, but aside from that, in four walls. But if this seems to be moving through the Senate, and if you have what your people on the scene say, we have enough positive influence that really doesn't have to go any farther. I mean, this is going to go through. Okay, then let's stop there and don't do anything. If there's a call, listen, we need some more help. We need to generate more media attention. We have a couple of key legislators in key positions who are opposed to this, that are on the fence. A politician who was on the fence with both feet on the ground, sitting on the fence. Then you have to manage to do that. I think it's that kind of a reading, and that's kind of a reading on every bill. But Ohio's a good state.
And I wanted to say one thing about that. We kept our mouths shut in Ohio because we didn't want the same opposition we had on House Bill 84. I mean, adoptive parents went crazy and attacked us verbally, physically, on the streets, wherever they could find us, when we worked on that for 5 years. But the news media, when it passed in the House, the news media came to us. I think they came to several people in several different, I'm not quite sure in Becky's case if they came to her or not, but they came to me in Akron and they said, this is what we know has happened. Will you comment? And I know they interviewed both at my group and in my home, probably total at least 2 hours. And what they showed on TV, I was so thrilled about because what part that they cut out and showed on TV was an adoptee wanting to search, why she wanted to search, and saying her adoptive parents supported her. And the other good thing about it was the fact that they said, well, is there any way birth mothers who don't want to be found can stop it? And yes, there is. They can file a denial, but they have to take action. They have to file the denial or they will be found. And I saw your news coverage, and I thought that was very good. They interviewed the young man, and he seemed to know what he was talking about. So I don't think we've gotten any, I know a couple of talk shows that a couple of people who have worked on this bill have been on, and I haven't heard of us getting, so far, any negative media
Not necessarily, I don't think it's necessarily that the media gives you negative attention, because the media is generally, in its news coverage, and this is not including the opinion pages and the editorials, generally in its news coverage is a predominant obsession to the point with balance. They want both sides of an issue covered. I think what Becky's question was more alluding to was, how public should we be about this bill? Because if it appears in the newspaper, sure enough, it's going to alert the opposition that this bill is even there. Should we be more appropriately just taking a real quiet, active role about this and not making it known to the general public?
To end the session with a series of questions that Sybil Coombs, who was on the panel originally from the state of Maine, asked me to read, and I would like to do that for her. But go ahead.
I just wanted to comment. The premise of what we're doing in adoption reform is gun secrecy and shame and all this other neat stuff that we've been having to live with. I'm an adoptee. I'm from Hawaii, where we just got a bill passed. And our premise was, and I'm not saying it's right or wrong, was that awareness and education is the other critical part of our goal. And so we gathered and garnered as much media attention as we could get. Taking the risk and the chance that we would pull out more opposition, and saying to ourselves, even if we do, what we're doing is educating that many more people. And we drew in a lot of closet people who were out there who didn't know we were there. I'm not an expert like these folks who can tell you when to do it and when not to do it. But my premise is that if we're going to fight for reform and we're going to be honest and we're going to be open and we're going to talk about the truth, then let's do that and let's not be afraid of doing that. And let's do it as loudly as we can so the whole world
I
can.
would just not hesitate to tell you that I'm very familiar with people in your group about it, and they're the ones who've been adamant that not any publicity go out about that bill existing at all. So you're telling an entirely different story from what my information is about the Hawaii bill and the strategy they wish to use about its publicity.
I just want to say one tactic, so semi-silent, gave it to Georgia, was being neophytes down at the State House and not knowing what to do. Some of the other professional lobbyists, when we explained what we were doing and how we were working, said, "Oh, you mean you people can't do that? Let me help you do this." We got a lot of real free help. And seriously, one of the problems in Georgia is you couldn't find out who was meeting when about what. We began to find out. And that, I think, was the biggest thing that helped us at least get it as far as it got this year. And then some other
Professional lobbyists, by the way, don't have horns.
No,
My father used to say, he used to come into my house and say, "You gotta get rid of those GD lobbyists." See, Dad, you know what I am? Really, they're a pretty nice guy.
Right.
And they
If
look
nothing
like gals, and they would have
nothing else to watch the Lions Den and us get crucified. But I don't care. It doesn't matter. The point was they helped us a lot, and they told us what was going on, and that came out of a sort of quiet approach as opposed to the more public. Because they were freer to do that, you see. Wouldn't jeopardize their position. That's the point.
Well, I think what some of this discussion is about is what I'm hoping will happen in the AAC and with other groups, and that is that we all learn each other's names, that we can all call each other as we're working on these legislative issues and help each other out with these problems. Sybil Coombs is a birth mother from Maine. She was unable to be here, and she, in the context of a statement about open adoption records as being just the first and not the only goal of adoption reform, which again is what Ken Watson was talking about, that in other words, those of us who've experienced adoption need to get out there and change adoption and perhaps even question the institution of adoption and so forth as we move along, has come up with a list of questions that she is hoping that we will all ask of ourselves as we pursue open records and adoption reform. Do you know the history of adoption in your state? Do you know when your state's records were closed? Do you know why? Do you know how many adoption agencies exist in your state? Do you know the agency's policies regarding all aspects of adoption? Do you know which adoption agencies in your state receive public funding and for what? Do you know the difference between state adoption law and adoption and agency policy? Do you know the licensing rules and regulations for agencies in your state for adoption social workers, adoption professionals? Do you know the appropriate authority where complaints against private and public agencies, social workers, lawyers, judges, and legislators can be filed in your state? Do you know about your state's foster care system? Do you know or can you identify services available to unwed teens and families in crisis in your state? Do you know about or have access to pre- and post-adoption services in your state? Can you identify the need? Do you know what insurance companies, carriers, or state and federal health care resources are available in your state that will help members of the adoption triad? Do you know who they exclude and why? Do you know about adoption interstate compacts, subsidized adoptions, and special needs definitions in your state? Are you aware of their problems and limitations? Do you know your state's definition of best interest of the child? Do you know the number of adoptions initiated or completed in your state in the past year, in the past 5 years? Do you know that if you can educate yourself on these questions, that you will be able to effectively advocate for adoption reform in your state? Do you know that equal access to services and records for all members of the adoption triad will only happen when ignorance is replaced with knowledge? It's your obligation to find the answers.
Linda, do you think you can make copies available?
I'd be happy. I'll do it here, and I'll leave it on the desk, one of the desks or tables out at the AAC registration area. The whole paper is excellent. Okay. Thank you very much. Thank you. Oh, yes, and do your evaluations for this workshop and other workshops that you go to before you leave or just as you're leaving. Check off if you have your evaluation forms. You're supposed to evaluate each workshop. Thanks.